format than many trials. But I hope that as we go through this, that your minds will be drawing on the things, the details that you heard, and that this format will make sense. I'm going to talk a lot about the things that Mr. Pesci addressed. So you'll see some of the slides that I bring up will be jury instructions that he has touched on. I won't spend as much time on the ones to not repeat ourselves. But I think there are some critical things that each of you needs to analyze and make sure that you understand as you're going through and evaluating this evidence when you finally get back into the jury deliberation room this morning. The first instruction I'm going to talk to you about is number 5, and that one has been touched on pretty early by Mr. Pesci. But again, it is critical, and in a bit I will bring up the instruction on the definition of reasonable doubt. But death sentence can only be imposed if you find unanimously and beyond reasonable doubt on the aggravating circumstances. But then that second part is also very important. Each and every jury determines that the mitigating circumstance or circumstances, if any, which he or she has found, do not outweigh the aggravating circumstance or circumstances. And this number 3, the jurors unanimously determine that in their discretion, a sentence of death is appropriate. So I think it should be clear in your minds, hopefully by this point, that even if you were to come to a conclusion that they have proven the aggravators, even if you were to weigh them against mitigators and you thought that they outweighed, you still do not have to impose a death sentence. I want to focus on this because it ties in some important testimony that was brought out through Warden Sherman Hatchet. And that is this possibility of parole. We all know we're dealing with a crime that took place 31 years ago. Johnny has been in custody since that, shortly after that time. So he's past that 20-year mark if he is given that possibility. But it was very clear from Warden Hatcher, and just to remind you of his background, 30 years working for the Nevada Department of Corrections, that even if somebody is given a sentence with the possibility of parole, that is no guarantee they will ever be paroled. And he told you he was aware of people who have had sentences of possibility of parole that have not been paroled. And I'll go through a little bit later on a slide, but the things that are considered by a parole board before anyone would be released. Okay, those have been covered. That last one, if you sentence the defendant to death, you must assume that the sentence will be carried out and then Mr. Valerio will be executed. Okay. Again, a lot of this has been covered. I'm not going to drill it too heavily into your mind, but you understand this proof of aggravators and then the weighing with the mitigating circumstances. And I will be focusing on those in just a moment here. Now, this definition of mitigating, or what needs to be found for mitigating circumstances. Again, that is not something that has to be found unanimously. If any one of you finds a mitigating circumstance, that is sufficient for consideration and weighing. The mitigators do not have to be found unanimously. And you'll see in your packet, 8 and 9, they explain a lot of detail, the interplay between the aggravators and the mitigators. And we know these are legal terms that you probably never really had to deal with, and they are the heart of how you come to an appropriate sentence in this case. Instruction 18, that is the instruction that focuses on the depravity of mind aggravator that the state seeks or has introduced evidence about. And I want to talk about some of the requirements before that finding can be made. The one, it has to be beyond a reasonable doubt, but also that the evidence of mutilation, it has to be beyond the act of killing itself. And I want to, you heard read into you the testimony of Dr. Norlander, the coroner who had done the autopsy 31 years ago, and the findings that she had concluded. Dr. Coates, he's the current chief trauma doctor at UMC. He deals with trauma cases on a daily basis, and you heard him talk about the many numbers of stab-related injuries that he treats on a yearly basis. But I want to focus on one section of his testimony. The question was, and you didn't say in your review of this that you saw someone cutting off or permanently destroying a limb. So I did not, or another essential part of the body. No, sir. And you didn't see someone cut off or alter radically or to make imperfect. No, sir, I did not. And if you remember, he'd gone through, read the entire testimony of Dr. Norlander, reviewed the autopsy report that she had prepared and all the photographs, and indicated that his opinion was in line with hers. And that opinion boils down to what she said in essence, and that he testified, quote, "We really don't have a single wound that we can identify. So hence all these wounds likely accumulated to the death." Question was answered, and when we say all these wounds, that is all of the wounds, including the stab wounds and the lacerations. Answer, yes, sir. You were probably overwhelmed with all the going back and forth of focusing on the cause of death. And the importance of that is because the only way you get to determination of mutilation is that it is proved beyond a reasonable doubt the cause of death from the injuries is beyond the act of killing itself. Dr. Coates testified that in his experience, in his review of these wounds, it was an act of frenzy and an incredibly fast attack that he could not say to a medical degree of certainty the cause of death was beyond anything other than the totality of all of the injuries. I'm not going to read the entire thing. You have instruction 19 with you, which is the definition of reasonable doubt. And this is a very focused description of what you jurors are to consider when you're trying to determine whether an element has been proven beyond a reasonable doubt. A reasonable doubt is one based on reason. That makes sense. But what I want to focus your attention to is the singular, is a reasonable doubt. As long as you have a reasonable doubt, that is sufficient. You may have other reasons that you think it's been proven, but a single reasonable doubt that fits this description of what needs to be in your mind is all that is required and all that you can allow under the law to find that the state has not met its burden on whatever element has to be proven beyond a reasonable doubt. Judge Johnson read to you the beginning of the jury selection, this concept of mitigation. It's just something that's very foreign, so I just wanted to remind that, go through that one more time, and focusing on fairness and mercy. So any factors, while they do not constitute a legal justification or excuse for the commission of the offense in question, may be considered in the estimate of the jury in fairness and mercy as to whether the defendant is worthy of a death sentence. Okay. I'm now going to take you through what we believe the evidence has established for this list of mitigators that's going to be given to you on the verdict. As you heard at the beginning, and you as included the instruction, there may be mitigators that you folks have picked up on that Mr. Pintaro and I have not listed here. And there's a section at the end that you can include those. But the first one, the youth of John Valerio at the time of this crime. Obviously, that is the biggest thing that's been talked about on both sides. This is a crime that took place 31 years ago. Now, it is a little difficult arguing things from John's childhood because of the age that he's at now. But I am going to just to put things in context of how he had gotten to the point in his life where he made such very, very poor and tragic decisions in that time period from when he was 18 through 21. But if you remember the testimony that was read from his sister Jewel, she's 2 years older than Johnny. There's pictures of the two of them that you've seen. And she talked about how very hurt he was by the separation from his mother in that divorce. And remember, the testimony was that the mother, Johnny was given the choice of which parent to live with, and he chose to live with his father, but Dr. Reutemann indicated, how he felt he was just way too young to have to make that decision. And kind of the mental consequences of that separation and then feeling the abandonment. That you heard testimony, his mother lived in their same town, and she would hardly have any contact with him or his sister as they grew up after the divorce. This was hit on by Mr. Pesci, but I do think this is significant. With the turmoil that he was dealing with at home, he did start using marijuana at a very young age. Did that through Dr. Valerio, and that inhibits the normal maturation process of a young person. His father indicated he was very busy supporting the kids, work shift, very rotating shift schedules, was often not at home, and where he testified that he often had a neighbor across the street would try to keep an eye on the kids when he was away at work. One of the things that came through testimony that was read in was, at the time of this crime, John was working as a plumbing assistant, and his employer spoke highly of him as far as the work that he was doing. Okay, I'm going to go through some things, jumping from 1986 and to his incarceration to 2017. You had the opportunity to hear from Johnny himself, and you heard a lot of information through Sherman Hatcher, through Dr. Reutemann, of these extensive prison records, and you saw the binders of how many, the reams of paper that have been kept on Johnny Valerio during the time he's been incarcerated. Everything is recorded. And from what Johnny told you himself, and then those prison records, you see the pattern of him starting to take responsibility for choices, starting to mature, and starting to make good choices eventually. Now, you heard from him, as well as Kate Stevens. And Kate is the friend of his who, about 9 years ago, reached out to him and started corresponding with him, and then has been out, I think she testified 4 times on her own expense to develop a friendship and a relationship with Johnny, and the things that she has seen him do, the perspective that she has, and the way that he tries to help those that, other inmates as he has matured and finally figured out the system and the consequences of choices. Okay. You obviously heard from his dad and his stepmom, and even at their advanced age, their relationship with Johnny is very important to both of them. They travel out here at great effort, given their age and Mr. Valerio Sr.'s physical conditions, to come out and see Johnny at least once a year. I've talked about Kate Stevens a bit. She, one of the things about her is kind of her background and her experience with people, and you heard from her testify that in her experience that Johnny has developed, kindness and qualities that we want in people. And she has no incentive to come and testify other than her friendship for him, and wanted to come and explain to you what she has experienced with the 9-year relationship she's had with him. Okay, that's just a fact. We know that he's done 31 years already as a result of this conduct. The last time that he had a write-up was 2001, and there was a lot of going back and forth with the testimony of Sherman Hatcher, who had reviewed the file from the prison records, and he testified that he had not seen any infraction since 2001. This number 15 ties in with what Sherman Hatcher said, the 60. And that in his experience in reviewing the early misconduct while he was in prison, and him starting to realize that he's responsible for decisions he makes even when he's in custody, that he progressed in accordance with what they want to happen in the Nevada Department of Correction. I mean, the focus of that system is rehabilitation. It doesn't work for everybody, but for a lot of people it does. A very good question that was asked of Sherman Hatcher. Person spends the majority of their adult life in prison committing a serious crime. How often, in your experience, does that person return to prison after being granted parole? And I'm quoting now from his answer. His answer was longer, but there are some key things that he told you from his 30 years in working in the prison system. Over the years, I've seen very few people who got out of prison after doing 30 or 40 years or so come back, unless it's for like a minor violation, like they failed to report, they didn't pay a fee, a monthly fee, they have to maintain employment. There's all kinds of things that can cause them to go back. Most of the people who end up back in prison after they've served that much time are not going back because they've committed a new crime. I think that's very, very important in the consideration of his record in prison, and then the experience that Warden Hatcher has with many, many prison inmates. Okay. And you heard this from Sherman Hatcher. I talked about it a little bit before. no guarantee that he's ever going to be released, even if he is granted the option of parole. And he talked, and Mr. Retrial will go through this in a little more detail, but the lengthy process that a parole board goes through in evaluating on an individual basis what the history of the individual they are assessing, whether they're likely to reoffend if granted parole. That's it. I want to talk a little bit about Dr. Reutemann. He went through a lot of different things from his 30 years as a medical doctor, psychiatrist, and the findings that have, for many studies, related to the development of brain functioning in young people. And he talked about how that 18 to 21 year period, a person's brain is not fully developed, and that the time when all of these crimes were committed, Mr. Valerio had not yet reached full brain maturation. And I want to quote the things that he, after reviewing everything, and Mr. Pesci, I think he forgot to, when he talked about the things that that Dr. Reutemann had considered, he talked about he'd done interviews with Johnny, he had done a questionnaire, and he had talked to the parents of Mr. Valerio. But he did mention that he'd also gone through the extensive medical and prison record of John and Valerio, which I think it was clear from his testimony that history was also very important in his final determination of his professional opinion, because that 31-year record is not something that can be made up, is not something that someone who's trying to look positive can create. That is the record that was created by the prison. So these are the things that he found. Mr. Valerio has redeeming attributes, lacks characteristics of mental illness or psychopathic traits, and has developed, and that's a verb coming forward, has developed into a pro-social individual who is not at risk to himself or others. We certainly are not claiming that 31 years ago he wasn't a risk to others. That's clear. He was a very serious risk to others when he was 21 years old. But what Dr. Reutemann has found is that Johnny has developed into a pro-social individual who is no longer a risk to others. You heard Johnny tell you that he has plans to continue being positive and trying to make good choices. You heard him express that there's not a day that goes by that he doesn't think of Ms. Blackwell and the great harm he's caused her family, and certainly his family. In that instruction that we went through, that mercy, that is, and Mr. Carl talked about that a lot. Okay. Last one is you guys can add things that we may have missed as far as mitigating circumstances that if just one of you finds, you can list in the verdict form. I'm just about finished. You have a monumental decision to make. I sincerely feel that each one of you knows that it's important and that you're putting great thought and effort into this, and we appreciate that. I hope that you are able to recognize what has been brought out through a number of people, that a person can truly change and sincerely change. And I believe that if you analyze the evidence that's been presented to you, that you will know that Johnny Valerio is not the person he was back in 1986. And I hope that when you do that, that you will give him the opportunity to be evaluated by a parole board. Whether they ever give him parole is up to them. But I hope that you will give him that opportunity.
Thank you, Mr. Erickson. Ready to go, Mr. Pitaro, or you need any time?
No, Your Honor. Okay, just about ready.
All right, we'll be pleased to hear now from Mr. Pitaro.
When we started this trial a couple weeks ago, I said then, and I say now, this matter is about the possibility of hope. That's what we're talking about. When Tom Erickson and myself stand up here on behalf of Johnny Valerio, what we're asking, the possibility of hope. You, as jurors, are limited to 3 and only 3 choices. And in the jury instructions, number 4, get it up here, you can see what they are as we've spoken about them all this time. Death, life without the possibility of parole, or life with the possibility of parole. Those are the 3 choices. No matter what you feel 31 years later should be done to John, if one of you think, well, after 31 years, I want to release him, you can't. You can't. So your 3 choices are death. I want you dead. That's what the death penalty says. That the jurors say, I want you dead. Life, imprisonment, without the possibility of parole, says, in very basic terms, I want you to rot in prison, and the only way you're coming out is in a box. I mean, that's really what life without the possibility of parole is. Life with the possibility of parole is just that. It is a possibility of hope that sometime in the future, certain things can happen, and you may be released, but not released. Now, the prosecutor stood up here and sort of poo-pooed the idea that life with the possibility of parole means life with the possibility of parole means that you're going to be released. That's not true. In juror instruction number 6, you were told exactly the opposite by Judge Johnson. Exactly the opposite. It says, if you life imprisonment with the possibility of parole, which he would be eligible, not that he's going to get, after 20 years. This does not mean he would be paroled, which the prosecutor said would happen. It means exactly the opposite. He would be paroled after that, only that he would be eligible for consideration for parole after that period of time. Eligibility for parole, the possibility of hope. Warden Hatcher came in and he was asked specifically, specifically, if he has life with the possibility of parole, does that mean he's going to get parole? And you remember what his answer was? It doesn't guarantee anything. The answer is no. He is not guaranteed parole. Now, you took an oath to follow and look at the instructions. And so I can't let it go that you are told that contrary to Warden Hatcher, and contrary to the instruction of the court, that it doesn't really mean what it says, because it does mean what it says. And as Mr. Erickson pointed out, that Hatcher, Warden Hatcher, said there's a lot of people who are eligible for parole that don't get it. And we'll get into that in a moment, but I wanted to clear that up right from the beginning. Just as it says, if you get life without the possibility of parole, it means exactly what it says. He's never getting out. He's never eligible for parole. And if you're sentenced to death, you as jurors, you assume when you make it that that execution will be carried out and he will be killed. So when we talk about this case and we talk about these factors and we talk about what the law is, we can see that it is a definite sort of thing. You get three choices and only three choices. And the choice that we are asking is the possibility of hope. That maybe next year, in the next decade, whatever, 20, whatever, that a parole board constituted by the governor of the state of Nevada goes through and they make that determination. What you were saying and what we're asking for you, at some point, please let them make that determination. The people who are there to make those determinations. There's no guarantee. There never was a guarantee. This case was always, from our perspective, about a possibility of hope. It sounds trite almost, but it is so fundamental to what we do. I think that one of the fundamental questions, we stand up here as attorneys and we spout and we talk and we wave our hands and all, but you people are real people. You come from the community. You're not stones. You have feelings. You bring that to this deliberation, which is what we want. That is the community to listen and make a decision. But one of the fundamental things that about this case is can a person change? I mean, if you do not believe in the redeeming, reforming, changing quality of the human spirit, then I can tell you, I'm not eloquent enough to convince you of anything else. I don't have that power. I'm not Abraham Lincoln who can convince you. And it's something that is there. So the question is, do you fundamentally believe that the human spirit is redemptive, reforming, and changing, and can be? Doesn't mean it has to be, but can it be? Fundamental question that is asked. The state said nope. Nope. You heard their opening argument? Nope. Human nature can't change. John Valerio can't change. No one can change. Change. How, in God's name, do we go from that sweet little boy with his sister, 7 years old, with a birthday cake, to John Valerio booking for them? It was a change. And how do we get to this John Valerio? The John Valerio who's over here now. Not the John Valerio standing at 6 or 7 with his sister laughing with a birthday cake. Not the 21-year-old John Valerio in handcuffs and a booking photo. We're here with the 52-year-old John Valerio. And that's what we're here to consider. When you came in, you were told, contrary probably what you were thinking, is that this sort of guilt phase has been determined, and it was determined 31 years ago. And you accepted it. You weren't going to hear a trial with all the stuff in it. The witnesses, you've got transcript instead. You had an old general assignment detective come in and say, I read this and this is what it means. What we come down to is, in fact, what it is today. The decision you make is not a decision 31 years ago. You can't transport yourself back 31 years any more than I can or John can. Now, that decision bases upon that fundamental question, can a person change? And as attorneys, that's what we get up and do. And you sort of think, what can I say that can make my point? Can a person change? First thing that pops into your mind is Ebenezer Scrooge. He sees 3 ghosts on Christmas Eve, and he goes from an SOB to the greatest thing since iced tea in the course of a few hours. But that's not the world, that's not the reality. I want to talk about another person who had to face that, who had to face the choice of change, who had to face the choice of redeeming himself, of reforming himself, or changing himself from what he was to what he hoped to be. This guy from history, his name was John Newton. He was part of a movie a number of years ago. He was very close with another historical figure by the name of William Wilberforce. Some of you people may know or not know. But John Newton, in his early life, was a slaver. He was a captain of slave ships. He went and made the rounds to Africa and brought back people. And that journey, committing atrocities, inhuman things, to not one, but a number of people, and he did it, and he did it, and he did it. He was, by all accounts, according to his acts, a bad man, an evil man, an uncaring man. But at some point, John Newton changed. He redeemed himself from himself. You don't redeem yourself from others, you redeem yourself from yourself. When you change yourself from yourself. When you reform from yourself. When you mature, when you understand, when you grow. Or as Warden Hatcher said, is you go through the aging. When that happens, you can change. Now, John Newton was a very literate man. And he tried to capture in a poem, if you will. He tried to capture the change, the redemptive quality that he found in himself, and which he found in everyone else. And you may not have heard of John Newton by name, but every one of you has heard of what he said. As a matter of fact, I read on Google that annually it is quoted 10 million times a year. You may have heard it with the great gospel singer, Mahalia Jackson. You may have heard Elvis Presley sing to Randy Travis. You may just a couple of years ago have heard President Barack Obama sing it at a funeral. What it was amazing grace. This was the most introspective feelings that he had to try to explain what he did and what he went through. And so the words he wrote were amazing grace. How sweet the sound that saved a wretch like me. I once was lost, but now am found. Was blind, but now I see. John Newton went on to become an Anglican priest. He became a very, very major mover against what he had started. He became an abolitionist in England and led to the helped lead to the eradication of slavery in England decades before we had it here. Now think of that. This is a man who was a slaver, who committed the atrocities, who changed and put it down, and changed a wretch like me. He believed in the redemptive quality. And the reason this song, this hymn, is repeated over and over, those old enough, some of you would never have seen it, but older, it was sung, as I said, at Ronald Reagan's funeral. It has been used by people to show the redemptive quality that the state rejects. When they stand up and make the argument that they made, they're good people, but they reject that redemptive quality. And we hope that you have that redemptive quality, and you can see it in others, and you believe that people can change. Now, when we go through this trial that we've gone through, we now know that John has been in for 31 years. And what we seek from you is the possibility of hope. And if you accept the words, if you will, the feeling, the belief of John Newton, that a wretch like him can change, that a wretch like him can see. If you accept that, then we can move on to John Valerio. And what we have to do with John is to see, has he changed? Now what we did in presenting this, we presented you with three, I don't want to say separate, but three different viewpoints. We brought in Warden Hatcher, who gives the institutional explanation or analysis of change, of John Valerio changing. From the institution, the prison, as a warden of 3 separate prisons in Nevada, I believe he said. So he has that understanding from that viewpoint. And I'll get to that in a moment. The second one we brought in was the medical, if you will, the psychiatric, the medical expertise of the mind, of the maturation process, of how that applies and how it affects. And so I'll call that the medical aspect of our testimony. The third one is one that I call the social, the family. We brought in John's father, who hobbled up with a cane, an old man now. His stepmother. We brought in Kate Stevens, who flew all the way from New England here, where she established a relationship through pen pal of friendship, not as a minister, but as she said, as her and her husband came to know John. We brought in some old transcripts that were read from 30 years ago. The essence of those transcripts, the essence of the testimony that came from up here to you was fundamental. We love John. John loves us. And John has changed. He is not the 18, 21-year-old person that he was. That with the 31 years in there, he has now become a person who cares for others, who is concerned of others, who discusses problems of others. He has left the meism of the criminal life to the usism of being a pro-social person. He's not mentally ill. He is not a psychopath. He is a person who has those feelings that you have. He has them towards his family and his friends, and they have them towards us. And that is something that has evolved. Although the love may have stayed constant, the evolution of John to accept that love and to give it back is the progress that we've talked about here. That's what we're talking about. You know, when we look at it, what happens? Let me go through Warden Hatcher, if I will. Warden Hatcher is a man who's had experience in areas that most of us, almost all of us, have never dealt with, and that is the criminal justice system. And he's seen it from the institutional side. And so what we did is we asked him to take the 31 years, if you will, of prison records of John Valerio and look at them and give his opinion. You saw the volumes that we had that we didn't introduce, but how voluminous they were. And what he told you was that there is a progression in prison. There is a progression from the beginning of the young person all the way down. There is a progression where I think it was called the age out. And he said that in reviewing that, the most serious violation he saw was that contraband one with the razor, the Bic razor. But remember what he said about it? He said, well, if you know those razors, they're very small. And John said that he'd use it arts and crafts, which they do, and it was given there. He said, well, that was the most serious thing. But there's nothing in his record of 31 years that John has ever been aggressive to another inmate. to a staff member, to a guard. The 31 years, if you will, leading up to here, the years in prison, we don't have that of John. And a lot was made on cross-examination of Warden Hatcher, where there was the form from the prison that John wasn't an aggressive person. They did that a couple of years ago. Oh, well, that was talking about someone else or something else. But when we went through just those records there, you kept saying, not a problem, not a problem. He's not aggressive. He isn't out there getting in trouble. He's not out there fighting. State says, well, there's a good reason. There's a good reason why for 16 years John hasn't done anything. He has been pretending. He's been pretending because in 2002, a hearing like this was honored. And so the state wants you to disregard all that and say, oh, he was pretending. The problem with that, of course, is twofold. One, this all started before that 2001 order. And actually, when you go through even back there, there was very minimal problems. But the last 16 years, nothing. Well, you don't not do something for 16 years because at the 15th year you found something out. The second thing is Dr. Reutman, in using his medical background, and remember, it's 30 years of dealing with people within the criminal justice system. He teaches at the medical schools here, the Nevada, the Toro, there was the third one that they had. He teaches as a professor there in psychiatric medicine. He's worked with the county and for the county. He has dealt with the Caliente area, which is a youth camp deal. He has had a private practice that deals with this, that deals with people, that deals with all the conditions of the mind that can get involved and thrown into the criminal justice system. And he said one thing that was very important concerning the government's, the prosecutors, oh, he's really just hiding up there in the prison for 16 years, being a good boy so that he can go out and do something bad. He says you can't suppress the bad things, the type of things, the psychopathic, the antisocial. It's got to come out. It would have to come out. You couldn't do that. And he testified that to a reasonable degree of medical certainty as a doctor. And when we go to doctors, we generally want to take their opinions. So when we talk about John, and we look at the institutional, we see that he has in fact changed. He's changed from the 21-year-old who went in to the 52-year-old man who sits here today. One of the other concerns, of course, and Mr. Erickson has dealt with it, and it is always out there, and that is, well, what if I let him up? Is he going to go out and commit another crime, a violent crime? First, now we know that the process is a little different. You don't let him out. You just say he can go to another stage and someone else can make those decisions. But you heard Warden Hatcher in response to the juror question. He said something that anyone in the 30, 40 years, very few people ever have a problem after that. And of that very few that he talked about, none of those is he aware of that has ever gone out and committed a violent act or another crime even. I think he said murder, burglary, or anything like that. Those very few that get in trouble is an inability to adjust maybe. They're supposed to have a job and they don't. But it has nothing to do whether he's going to go out and commit another crime. Now, you are hearing that answer in response to a question from a person who has been the main person in charge of 3 prisons in the state of Nevada. If you can't accept his opinion on that, there's nothing I can say. Dr. Reutemann looked at what it was. And he came to the conclusion, he's not aggressive, he said. He is pro-social. He's not antisocial. Now, it was stated that he somehow didn't do a good job. He's done it for 31 years. They didn't bring in any psychiatrists that said he didn't do a good job. They didn't bring anyone and say, oh, Dr. Reutemann didn't do a good job. They said, well, I remember a case where a guy who wanted the jury to execute him was saying things and I didn't put it in my report. Yeah, I kept that bad stuff out because it wasn't relevant to what it was. That's what Dr. Reutemann said. But Dr. Reutemann came in based upon his 30-odd years of doing this sort of work, of dealing with people of all types, of all ages. And he explained to you that maturation process, the growth, that people like John Newton's, people can change. And he said to you, based upon his opinion, to a reasonable degree of medical certainty, he said he has. And if you can't accept Dr. Reutemann's opinion on that, based on his experience, uncontradicted, uncontroverted by anyone from the state, then there's probably nothing I can say. But that's what we brought forward to you to show that. The third thing were the family members, as we said, the social thing, the growth that he's had. And that growth is very, very important. You know, we took about 31 years, and I look out at some of the jurors, and they weren't even alive when this happened. And some of you may have thought it strange, like talking about presidents, talking about Ronald Reagan. Well, he was the president at the time. You have to think back, you know, in a courtroom, we see something up there, and it's so instant, it's so there. But by putting it in the context of how many presidents have been out there, it gives you an understanding of how long this process has been going on and how long the change has been going on. Going back, the offense when Reagan, President Reagan, all the way through now, President Trump. We had 4 years of George Herbert Walker Bush, 8 years of Bill Clinton, add on 8 years of George Bush, add on another 8 years of Barack Obama, and then now we're in the first year of President Trump. That's a long time. That's a long, long time. And during that period of time, John Valerio has been in prison, attempting to grow. He's been attempting to grow. And to me, that is what we tried to show. And what we asked you with that growth, that change, over this 30 years. We can't throw that 30 years away. And we can't change that 30 years for Karen Blacklock. That's not what these things are about. We can't make those changes that all of us now wish we could make. And John Valerio told you definitely he wishes he could have made the choice different. But that's what it is. So we have to look at where he is today. Now, Mr. Erickson went through, if you will, what we call mitigators. We use the term mitigators, aggravators. But I want to deal with one mitigator that I think goes back then to the essence of what it is, of what the possibility of hope is. It's not that he's getting out. It's not that he will ever get out. The only difference between life without the possibility of parole and life with the possibility of parole is something that is done down the line, where a parole board gets everything, not only all the records, all his records, plans, things are going to happen, what they can do. It's a very elaborate process if you've never gone through it. We just had one, at least on TV, that gave some insight into how involved and complicated it can be. But what it comes down to is the last, if you will, mitigator. Get that there. Improve it. Even all the high-priced, brilliant talent here, we still can't get the page right sometimes. But I look here at number 21. I'm going to ask you to look at it. And it's a question you're going to have to answer. Defendant John Valerio may receive mercy in his sentence. Now the other mitigators are more factual. Was he in prison 31 years or not? Did he have a problem with his mother leaving him or not? Was there an offense or not? Whatever those say, those are factual things. You have to make a decision. But the issue of mercy. Now remember, our law, as the instructions you would see in there, it says mercy, and we talked about it, is encompassed in justice, not revenge, but justice. And so what is mercy? Once again, someone has said it better than I ever can. Now with mercy, mercy is not something that I or anyone can force you to do. Mercy has to come within the self. It has to come from within the self. And remember when we started, and you will see the instructions in there, that mitigators are not unanimous. Well, they don't have to be. The unanimous verdict of a jury is for a person to get death, it's got to be unanimous. For a person to get life without the possibility of parole, you all have to agree to the same punishment. If it's going to be life with the possibility of parole, you all have to agree to that for that to be. But if you don't agree, if some of you, as we said, stand up for this viewpoint or that viewpoint, as the jury instructions tell you, that's individual. And so when we talk about your decision being an individual decision, that's what we mean. And the court has told you that any one juror can find any one mitigator, and that's enough. And if that one mitigator does not, you finding that mitigator, or even none, but finding a mitigator that you don't have to give a punishment, that your other people may want, good or bad from other people. It works all the way around. But one of them, the last one, is mercy. As I say, you may have heard this before too, but it's this. The quality of mercy is not strained. The old word strained meant cannot be compelled. So the quality of mercy can't be compelled. It falleth, it droppeth like the gentle rain from heaven upon the place below. That is, it is not something that you can figure with. It is something that comes from above. all within. And then he says, the quality of mercy is twice blessed. Not once blessed, but twice blessed. The quality of mercy blesses they that give it, that they receive the blessing with the quality of mercy. And it's twice blessed. And the person who receives the quality of mercy is also blessed. And so, as we're done, the last time we'll talk to you, we ask you to remember the quality of mercy to your own humanity and the changes that have gone on in 30 years. This is not a decision that we would have made or could have made or might have made 30 years ago. This is a decision that you must make based upon today. You are now sentencing John Valerio, 2017 at age 52. You're not sentencing John Valerio, 21, 1986. So the quality of mercy is not strained. It drops like the gentle rain from heaven to the place below. It is twice blessed. It blesses him that giveth and him that receives. Thank you.
Thank you, Mr. Retrial.